Welcome back to Liberty Bites on the Think Liberty Network. I'm your host, William Gadsden. You can follow me on Twitter at William_Gadsden and follow Think Liberty on Facebook, Twitter, or whatever your favorite social media outlet is. You can also follow me on Facebook at William Gadsden, Political Commentator. Give us a follow and a like for updates on new episodes and more. We also have a Patreon now, so if you'd like to support our work, check it out at patreon.com/ThinkLibertyPatrons. So this is a wrap-up for our Supreme Court series, and it will be a little short. But we'll be using an entirely new format for this show starting next week. So, take what you're going to get. So over the course of this series, we've gone over a ton of information. We started with some general concepts, like what the rule of law is, how it should be applied, different quote-unquote interpretations of the U.S. Constitution, and different judicial philosophies. We then covered some of the most constitutionally impactful cases that the Supreme Court has ever ruled on. So I have some questions for you. What themes did you see in these rulings philosophically or pragmatically? What rulings would you have made differently and why? Do you think the Supreme Court is a net benefit to liberty or a net loss? Now, while the Supreme Court was originally intended to be a check on the executive and legislative branches as a separate and weak branch of governance, has it ended up serving only to vindicate those in power? In Federalist number 78, Alexander Hamilton writes that the Supreme Court should be the weakest of the three branches because it has, quote, no influence over either the sword or the purse, and that it, quote, may truly be said that to have, and that, quote, it may truly be said to have neither force nor will, but merely judgment. At the same time, though, I would point you all to the Hamilton quote I used in the first episode of this series from Federalist 81, in which he says, quote, the authority of the proposed Supreme Court of the United States, which is to be a separate and independent body, will be superior to that of the legislature. The power of construing the laws according to the spirit of the Constitution will enable that court to mold them into whatever shape it may think proper, especially as its decisions will not be in any manner subject to the revision or correction of the legislative body. This is as unprecedented as it is dangerous, unquote. This is what I personally believe our current situation with the Supreme Court has ultimately come down to. We have gone from equal application under the law, from a situation in which we expect and trust the justices in power to apply the law and the Constitution as it is written, regardless of their personal political leanings, to openly and publicly keeping count of how many right-leaning and how many left-leaning justices are sitting on the court. Both political sides cheer on their favored justices, hoping that they will make indelible marks on the ultimate law of the land based on their own political biases. In my estimation, we have entirely missed the whole point of the Supreme Court. It has turned into the monster that Alexander Hamilton feared, and we have nobody to blame but ourselves. I know this series is ending on a bit of a down note, but the future is still ultimately in our hands. And at least if I have anything to say about it, it will be centered in liberty. So thanks for joining, and I hope you'll come back next week to become more liberty-centered with me. I'm William Gaston with Think Liberty.